Good morning. Good morning. Today we're going to talk about child support and how it impacts your ability to meet the financial needs of your children. What we're going to talk about today is how many of you may owe child support. We're going to talk about some of the things that you can do while you're incarcerated and some of the actions you can take upon your release to try to get your child support to be consistent with what you have as an income upon your release. What I want to start with a little bit is just to give you an overview of some of the facts about child support. One of the things you need to understand about child support is the reason we have a child support agency is to try to help custodial parents get assistance in meeting the financial needs of their children. We are working for the children. We truly are. And there is a non-custodial parent who is out there who is not paying their child support. So someone is paying to raise that child, be it the taxpayers, be it the custodial parent maxing out their credit cards, relying on their family members to help support the kids, whatever the scenario is. Our job in child support is truly to try to get that non-custodial parent to contribute financially to those children. Who's the custodial parent of your children while you're incarcerated right now?
I signed full rights to my grandmother.
So it may be the grandparent, it may be the mother of your child, or it may be an aunt or an uncle, or in some situations it may be foster care. So in those situations, what child support does is we assist the custodial parent in obtaining financial support from you. So today we're going to talk a little bit about what that financial support entails.
Now, my grandmother, she put them on child welfare, right? Now it's up for us as the parents to pay for that?
Yes. The question is, the children are on public assistance with the grandmother. What happens in that scenario is both the mother and the father become the non-custodial parent because neither of you have custody. So in child support, we will pursue child support from both you and the mother of your child. And we'll establish separate court orders to get child support from both of you. That's how it works when kids are in foster care, or they're in guardianship care, or they're in custody of someone other than the biological parents. Okay? I'm going to go to the gentleman right here in
No, to my understanding, when I got put on child support, wasn't you supposed to pay child support to the age of 18, not 21?
Depends on what the question is, how long does child support last? It depends on what state you had a child support order in. New York State, child support is until the child turns 21 years of age. Some other states are 18, some other states are 19, but in New York State, it's until age 21 or unless the child becomes emancipated before then. There's two streams of individuals that come in and apply for child support. The first stream are individuals who are mandatorily having to apply for child support. Those are people who apply for temporary assistance. They have to apply for child support. The second stream are individuals where it's a private case. What I mean by a private case is basically the mom and the children are not on public assistance, and that's what a private case is versus a public assistance case. There are some of you who had a child when you were not married to the mother of your child. We call that an out-of-wedlock birth. What we see with incarcerated individuals is about 60% of the incarcerated individuals have children, but many of you were not married when you had a child. And so in those situations, you need to figure out how to establish paternity for your child. So there's a couple of ways to establish paternity for your child. The first way is that you and the mother of your child could have, when you were at the hospital, you could have signed what we call a voluntary acknowledgement of paternity. What the voluntary acknowledgement of paternity is basically you and the mother would sign a paper at the hospital. Both of you would have agreed that you were the father of the child, and then you would have signed the paper, when had it witnessed, it would have been filed, and your name could have been on the birth certificate for the child. So that's the easiest way. About 66% of the children who were born out of wedlock, the parents signed the acknowledgement of paternity in the hospital. For those of you who may have had doubts as to whether or not you were the father of the child, maybe she was dating someone else, maybe you had broken up at some point during her pregnancy, and you maybe weren't sure that you were the father of that child. In those scenarios, what we recommend is that you actually file a petition in court for an order affiliation. What the support magistrate will do is order DNA testing or genetic testing. It's just for the purpose of establishing paternity. So if you went to court and did DNA testing, or you signed an acknowledgement of paternity, you have the same rights and consequences once you go to court or sign the acknowledgement of paternity to that child. Now, while you're incarcerated, there is the possibility that the DNA lab can do the DNA testing. And they work with the counselors and they'll do the DNA testing. And DNA testing is only for the purpose of child support. We don't use it for any other reason. It doesn't have any criminal consequences. It is just for the DNA testing for child support. If a child is born out of wedlock, if you don't establish paternity at that point, you can't have your name on the birth certificate in New York State, or actually in any state. The other thing is, when you get out, if you wanted to seek custody or visitation with that child, if you have not legally established paternity for that child, you cannot have custody and visitation. So for a child born out of wedlock or to unmarried parents, you have no rights to that child or no relationship to that child until you either establish paternity voluntarily or until you go to court. So those are some of the reasons that you want to make sure that you establish paternity. This gentleman up in the front.
Okay, I have a question. All right, now say, I had a baby out of wedlock, but I acknowledge the fact that that's my child, and I did, what I needed to do to take care of the child, but I never signed a paper stating that I was the paternal father, and so happened I'm not in the picture right now with the mother, and she filed for child support. How would that affect me?
Okay, in that situation, because you haven't filed an acknowledgement of paternity, when the mother applies for child support services, child support will file a petition to establish paternity. It's called an order. We're looking to get an order affiliation. And so child support will assist the custodial parent in filing that petition. We'll do DNA testing. We'll request it as part of the support magistrate's hearing for establishing paternity. So you'll get DNA testing unless you're willing to voluntarily acknowledge the child as yours. You'll get DNA testing. And so until that establishes you as the father, either through voluntary or going to court to get an order affiliation, we can't get child support for an out-of-wedlock child. We have to establish paternity in an out-of-wedlock case first before we can get a support petition. What you have to understand is child support covers a lot of needs. The child support will cover transportation of that child to and from school, after-school activities. It pays for part of the rent, it pays for part of the car, it pays for the food. Child support provides for a lot of different things. So think about it. If you have a $100 a month child support order, how much do you think that's going to pay for a kid? It's not going to really, right, it's not going to provide a lot. And so we look at it, and I'll talk about the calculation. So when you start looking at how much it costs to raise a child, when you start looking at the percentages of what someone may pay, what we do when we determine our child support guidelines, and I'll talk about that later, the child support guidelines basically look at how much it costs to raise a child from the various things, be it food, clothing, transportation, shelter, various things. And we try to make that consistent with what the guideline amount will be. So if you get a petition to appear in court, don't throw it out. Don't ignore it. That's the worst thing you can do. While you're incarcerated, you are still entitled to appear at your child support hearing. That occurs through what we refer to as telephonic testimony. What you want to do is talk to your counselor. Say you got this petition to appear in family court and that you want to appear via telephonic testimony. What that means is simply you will call into court. What you have to do to appear at telephonic testimony is when you get that petition saying on September 30th they want you to appear at family court, you have to send a notice back to family court and ask them, can you schedule a telephonic testimony? They'll send you a time and a date to appear at your hearing. Your counselor will assist you in making that phone call. So don't ignore it. The worst thing you can do is ignore that petition, that summons to appear in family court. Because if you ignore it, we by default, meaning in your absence, we can establish paternity. Without the non-custodial parent being there, we can establish paternity. We are allowed by law to do that. We can establish a child support order without you being there by default. Okay. So the worst thing you could do is not appear at your hearing.
Is there a set percentage you have to pay child support?
Child support is based on the Child Support Standard Act, which establishes percentages based on the number of children. So what the Act says is that for one child, you're going to pay 17%. 2 children, 25, 3 children, 29, 4 children, 31%, and then 5 or more children is at least 35% of your adjusted gross income. So the support magistrates are going to follow those guidelines when determining how much you're going to have to pay in child support. Let's use an example of 2 scenarios. The first scenario is where Fred has 2 children with Wilma. In that situation, I talked a little bit earlier about what the percentages are. In that situation, Fred would actually owe Wilma 25% of his adjusted gross income. So let's use the example of Fred earning $20,000. 20,000 times 25% would mean that Fred would pay $5,000 in child support each year. So that's pretty straightforward. Well, what happens if Fred has multiple children with multiple women? Well, what would happen is the guidelines would kick in as well. So if Fred has 1 child with Wilma, he's going to pay her 17% of his adjusted gross income. So he would take $20,000 times the 17%, which would be $3,400. What happens when someone else comes into the courthouse after, say Jane comes into the courthouse after, what would happen in that situation is Jane's court order is going to be based on the remaining amount from when the support magistrate takes the initial amount out. So when you get the calculation of the $20,000 minus the $3,400, what's going to happen at that point is that leaves Fred with $16,600. Well, Jane's order is going to be 17% of the $16,600. And what that will be is $2,822. So you have Wilma getting $3,400 and you have Jane getting $2,822. So there's a little bit of a difference between the two. So that's why when we talk about the guidelines, there is a distinction between having multiple children with one woman versus multiple children with multiple women. Because in the first case scenario, Fred owed $5,000. Well, in the second scenario, where he has multiple children with multiple women, he's actually going to end up paying $6,222 in child support for 2 children because he had children with 2 different women. So the calculation, though it's the same because it follows the Child Support Standards Act, it's going to be a little bit different because we're talking 2 different individuals.
Before I came to jail, right, I was ordered to pay $25 a month, right? At the time I had owed $3,000. Since I've been in jail, it's been accumulating. I'm still getting in the mail. It's still adding and adding up.
Right. The fact that you became incarcerated doesn't mean that your obligation to pay child support ended. You still continue to owe child support at the rate you owed prior to becoming incarcerated unless you filed a modification petition since you've been incarcerated.
I have to file that?
Yes. Right, because one of the things you have to understand with respect to child support is we in child support may know you're incarcerated, but we cannot change how much you owe. Only the court can change how much you owe in child support. So you have to file a modification petition. Now, one thing to keep in mind with your current situation is that the law states that if someone voluntarily changes their circumstance to avoid paying child support, say for example they quit their job or they decrease their income, then they're not eligible to receive a modification because they changed their income for the purpose of lowering their child support. Incarceration is voluntary unemployment, which means you're not eligible for modification. However, with that said, certainly you are eligible to file a modification petition while you're incarcerated. Whether or not the support magistrate will hear that is a different story. That's certainly within their discretion to see whether or not they would like to hear the hearing, or hear the child support matter. I can't make any guarantee that if you file a modification, you're going to get a poverty order while you're incarcerated. Certainly, when you're released, one of the first things you should do is file a modification petition. You have a change in circumstance at that point that is not related to your incarceration. You're out, you're unemployed, maybe you're working an hourly job, and at that point, you certainly want to file a modification petition.
How will they start this? Will they start from back or from the time that you appear to court?
In a modification petition, if I'm the custodial parent and I file a modification petition, what the court will do is look at the change in circumstance from the original order, but it only goes back to the date that I filed the petition. or the non-custodial parent filed the petition. So it only goes back to that date. So when you're released, if you want to file a modification petition because you've experienced a change in circumstance, in that situation, it'll go back to the date you filed the petition, not back to the date you became incarcerated. Okay? It goes back to the date that you filed the petition. So when you get out, that's one of the things that you might want to consider. You could talk to your parole officer, and they'll hopefully direct you in the right direction as to what you need to do to file a petition.
Say the non-custodial parent has a judgment to pay child support, and he's paying, say, like $100 a month, and he becomes incarcerated. Based upon his salary in prison, which we know is real low, but he still want to take care of his child, does he make payments through you, or does he pay payments directly to her?
If you have a child support order, you have to pay through the child support office. You don't have a choice. You have to make it through the child support office because we keep track of how much you pay. And so we give you credit when you make payments. If you don't, if you pay the mom directly, if that's a custodial parent, if you pay the custodial parent directly, you don't get credit for those. The gentleman behind him, and then we're going to work our way that way.
For me to keep paying my child support, I could send money to where I'm at from jail to the child support people, and they keep up the payment.
Absolutely. I know that there are actually a number of inmates who are making their child support payments from their commissary account. Certainly you would talk to inmate records or your counselor, and they can arrange for you to do that. If you have the resources available through your commissary account, certainly you can do that. When you become employed, if you owe child support, we will send what we call an income execution to your employer. It's paperwork. It tells the employer how much you owe. So say, for example, you owe $100 a month in child support. We'll send the paperwork to your employer and say, please take $100 out of his income to pay his child support. Now, if you owe past child support, so you're in arrears, past due child support, we will tag on an additional amount to cover that amount, that's to try to recoup that additional amount that you owe. So if you owe $2,000 in child support, we will try to increase a little bit with the $100 plus X number of dollars to try to make up that $2,000 that you owed. So when you become employed, yes, please anticipate within the first couple of weeks of becoming employed, your employer will receive an income execution from child support, and it'll tell them how much they need to recoup with respect to child support. Out of your they'll garnish your wages for that.
If you owe money and you file taxes, will they stay with your taxes? And if you have money in your account, will they freeze your money, take money out your account in the bank?
There are a number of enforcement mechanisms that child support can take without going back to court. We call them administrative enforcement mechanisms. Basically, what we do is a bunch of data matches with various organizations. If someone owes past due child support, we will do data matches with Department of Taxation and Finance, Department of Motor Vehicles, other financial institutions. So we do a variety of data matches in order to try to figure out what assets may be available to the non-custodial parent who hasn't paid. One of the things we talked about was the income execution. Once we find out someone's employed, we will send an income execution to the employer. Another thing we can do is if someone owes child support and they owe X number of dollars, well, we will send to both the federal and state tax